Claiborne, stop. What's the issue?
The issue is that nobody has contacted me to let me know that it's approved. This is my first time hearing that.
Okay, now that you've heard it.
My question is when will it take place?
What's your question?
When will it take place?
Do we know?
I just received notification that it was approved. I think she should contact her property manager.
Okay, you have to contact the property manager to see when that will take place.
Okay.
And then the other thing is that the check was received, so she's at a zero balance, and then that process has been approved. Any other objection you'd have to the dismissal, Ms. Claiborne?
No, besides my other service requests, I just wanted to know when those will be done too as well. So I guess I need to contact the office. So in the case that they say if they don't do it within the next month or so, what would be my next step? Can I put my rent in escrow? What are the steps to that?
One.
Court calls the case, People versus Shante Wingard.
Good afternoon again, Your Honor. Raymond Cook for the people.
David I. Goldstein appearing on behalf of the defendant.
All right, what are we doing?
Your Honor, I did explain to her that after our conference that yes, if she does take the deferred sentencing, she can she can report by Zoom, or by email, sorry. I also explained to her she was concerned about having to do drug testing and alcohol testing. I told her that's not likely in a case like this. She's not been testing all along, so there's no reason to expect that. And that most likely in a case like this, you would give her a 6 month, although there's no guarantee of that. You would most likely give her a 6 month. And based upon that, she indicated she will accept the offer.
All right. Go ahead, or sworn.
Raise your right hand. Do you solemnly swear to affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
State your name, please.
Shante Wingard.
Ma'am, you're going to plead no contest to the charge of retail fraud in the third degree. Is that correct?
Correct.
It's a misdemeanor, punishable by up to 93 days in jail, $500 fine plus court costs. Fine could be increased to 3 times the value of the property taken. If that's greater than $500, that would be the maximum fine. Do you understand that?
Yes.
I'm sorry, Your Honor. I thought you said guilty, she's pleading no contest.
I should have said no contest. That's what I meant.
Okay. Okay.
All right. You understand you're pleading no contest, man.
Yes.
You understand what a no contest plea is?
Yes.
You understand that with a no contest plea, it means that you're not desirous or wanting to contest this charge. You understand that?
Yes.
Second thing you need to understand is that for purposes of sentencing, the court will treat you the same as though you had pled guilty. You understand that?
Yes.
Basis for the no contest plea, Mr. Cole.
Civil liability, Your Honor.
Ma'am, to that charge, how do you plead?
No contest.
You understand by pleading no contest, you will not have a trial of any kind. You've signed and gone through an advice of rights form, is that correct?
Right.
Any questions about any of those rights?
No.
On the podium, please look at paragraph 5. Those are your rights which are part of a trial. You understand that by pleading no contest, you're giving up those rights as well as all the rights on that form.
Yes.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been said today to get you to plea?
No.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily and of your own free will?
Yes.
And also because you believe that you're indeed guilty of this offense?
Yes.
Well,
I mean,
No contest.
don't answer that. That was my problem. Court has been provided, it's like Pittsfield Township Police Report for their case number 25562. Any objection to the court having reviewed that report?
no, Your Honor.
Based upon a review of that report, the court does find that there's sufficient basis in which the court could determine the defendant's guilt of this offense to dismiss count 1. Ma'am, I do have to advise you that if you commit misconduct as defined in Michigan court rules between the time I accept your plea and the time of sentencing, the court that you would not be permitted to withdraw your plea, and the court would not be bound by any sentence recommendation or evaluation. You understand that?
Yes. Yes.
Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
None from the people.
No, Your Honor.
Have I complied with the court rule?
Yes, Your Honor.
Yes, Your Honor.
Court will accept the defendant's no contest plea to count 2. Count 1 is dismissed. Defendants referred to probation for a pre-sentence investigation and report and consideration of deferred sentencing. sentencing in this matter will be
May 13th at 9 a.m.
May 13th, 2026, 9 a.m. Bond with its conditions will continue. Ma'am, on your way out, stop by my probation department on the way down so we can start the process.
Okay.
All right.
Okay, thank you, Your Honor.
Thank you, Mr. Gold. Okay. Court calls case, People versus Kayla Walden.
Good afternoon, Your Honor. Raymond Cook for the people.
Ron Brown appearing on behalf of Kayla Wald.
She here?
Nobody's answering.
Your Honor, this is another situation. In full candor to the court, the people were unable to proceed today. I leave it to the court's discretion if the court wishes to proceed.
People being unable to proceed. Thank you, Mr. Cliff. You're moving to dismiss.
Move to dismiss.
Case is dismissed. That's without.
Thank you.
These are the last two.
Court calls case, People versus Angela Stoker.
Good afternoon, Your Honor. Raymond Cook for the people.
Ron Brown appearing on behalf of Ms. Stoker.
Your name?
Angela Stoker.
All right, where are we on this?
Formerly, or she previously waived jury.
Correct. And so we don't have a resolution today.
No,
Set it for today. So we already have a non-jury time. Well, I put the 29th. That,
That would be the Wednesday trial date.
right.
That's correct.
Is that the date we set? All right. So this matter will continue to non-jury trial on the 29th at 9 a.m.
thank you.
Okay. Thank you.
Thank you.
Thank you, Ms. Stoker.
Thanks.
Court does call the case People versus Kawandake Thomas.
Good afternoon, Your Honor. Raymond Cook for the people.
Ron Brown appearing on behalf of Ms. Thomas. No, nobody answers, but Your Honor, from Community Corrections, we've received a completion of treatment from the supervising agent.
Know that excuses her non-appearance.
Your Honor, rather than issuing a bench warrant, could we put it over for a week so I can find her?
Well, I can't because I don't have jury selection.
Well, I don't think we're going to jury selection because the prosecutor and I are aware of a pending felony matter where we're trying to create a global resolution to encompass this case or include this case.
What, another felony?
She, I believe, has a couple other pending felony matters up in circuit currently. Can pull up an Odyssey to see when those next dates are. I don't know that off the top of my head, but if I can just 1 second.
I think I got 1, 2, 3, 4 felony within a week.
I gotta find her.
Yeah, I know. But what I'm gonna do is I'm gonna issue a bench warrant. It will not for a failure to appear at these proceedings, because I just don't know where she is. And I'm not aware whether circuit court does either. Set the bond at a $10,000 cash surety, but I won't have the warrant issue until the 17th.
Thank you.
Thank you. Is that it for my morning? And then for another tenant. Thanks, guys.
Thank you.
Thank you, Your Honor.
Court is standing recess.
All rise.
Sir.
Hey, Brian, stop. Go ahead, Ms. Gazar.
This is also the one where Ms. Claiborne had submitted a 504 request, and that has also been approved.
So her request was approved. All right, Ms. Claiborne, what's the issue?
The issue is that nobody has contacted me to let me know that it's approved. This is my first time hearing that.
Okay, now that you've heard it,
My question
Is
is, when will it take
there any-
place?
What's your question?
When will it take place?
Do we know?
I just received notification that it was approved. I think she should contact her property manager.
Okay, you have to contact the property manager to see when that will take place.
Okay.
But, and then the other thing is that the check was received, so she's at a zero balance. And then that process has been approved. Any other objection you'd have to the dismissal, Ms. Claiborne?
No, besides my other service requests, I just wanted to know when those will be done too as well. So I guess I need to contact the office. So in the case that they say if they don't do it within the next month or so, what would be my next step? Can I put my rent in escrow? What are the steps to that?
Ma'am, you can do what you wish to do. I can't advise you of that. All I know is that the issues that are before me at this point, all of them look resolved, and I can't. There's nothing for me to try. And they're seeking to dismiss the case. So
I understand that, sir. Your Honor, what I'm asking is how do I go about putting my rent in escrow if it's not completed? Because this is affecting
I'm gonna suggest that what you do is you contact an attorney as to how to do that. I can't give you legal advice. Okay?
Okay. Thank you.
All right. Your case is dismissed.
Thanks.
Court calls case of Eladot Property Management versus Nicole Freeland
Very related.
and Aaron Gates. Freeland, Gates, they are not here. If you'd like to call, raise your right hand. Solemnly swear or affirm testimony you're about to give will be truth, whole truth, nothing but the truth, so help you God. Go ahead.
Non-payment of rent. The rent to retain possession is $1,156.83 for cost of $325 for a new redemption of $481.83. Plaintiff is requesting a default judgment. The writ to issue after 10 days if the total amount remains unpaid, as well as a money judgment. That amount, I believe they were present.
They were present. Judgment to the plaintiff, that is by default for possession and money, redemption amount, money judgment in the amount requested. Writ to issue in 10 days. Court calls the case of Evergreen Apartments versus Mia Garrison. Mia Garrison, no response. You may proceed.
Thank you, Your Honor. The rent to retain possession is $6,107.09 for a cost of $170. Redemption of $3,279.69. Plaintiff is requesting entry of a default judgment for possession only with a writ to issue after 10 days. The total amount remains unpaid.
Judgment to the plaintiff by default for possession, redemption amount in the amount requested. The writ to issue in 10 days. Evergreen Apartment versus Dwayne Watson.
Marissa Gazzari for plaintiff.
Good afternoon, Your Honor. I'm Dwayne Watson.
Good afternoon, sir. All right, where are we on his?
Your Honor, balance is $3,510. And that the Hawk application was denied.
What I'm looking for on this sheet. Watson. Got it. Okay, client is the last you have that it was denied.
Yes, the note that I have from my client says that there wasn't sufficient income for their requirement.
Okay, when did you get that message? So this is where.
It's from my client. It just came through to news. I don't know when it was.
Got it, because the sheet they sent us says client is sending last check stub 49 for eligibility determination. Did you already do that, sir?
Yes, sir.
When did you do that?
Okay. The last time I was in court, I talked with the Hawk organization, talked with Alicia Sykes. What the attorney said is correct, but things done changed as of today. I talked with Hawk.
When did you last talk with Hawk?
Today. I talked with Miss Alicia Sykes. I also talked with Miss Sydney. I can't think of her last name.
What did they tell you?
Well, I've paid over $1,000 this month. So my remainder balance is $2,996 and some change. I talked with Alicia Sykes today. She said that everything what I did, if they approved of the grant to take care of the remainder balance. I also
What time was that conversation?
this was about I want to say about 9-10 o'clock this morning.
And you get a message saying he was denied sometime today.
I can message Sykes, see.
Sure. All right. Why don't you have a seat?
Yes, sir. Thank you, Your Honor.
That's the problem with this paper thing that they have now, because things can change, and it was much better when we had Amy present. Well, I guess that's not up to me. Gulfside Lake, 1 and 2 versus Lakia Williams
There.
and Coran Williams. Lakia Williams, Coran Williams. Okay, have you received their check for 3,000?
Well, I have their balance as $1,660.
That be April?
And the $3,000 check came in on the 3rd of April. Or maybe it was the 2nd of April. And it was applied to the ledger. So yes, my balance is,
Is her April rent?
yeah, all these.
Oh, boy. Okay, so here's part of the problem. Part of the problem is she's not here because she's always here. She's not here because she got her balance down to 3,000. They said they were going to pay it. She believes that she's clear. I'm sure of it.
My notes from the last hearing indicate that she was gonna pay April rent by the 3rd.
Oh, she was. That okay, I don't have that. Let's do this because otherwise what's going to happen if I don't think I could properly dismiss it. Let's try to give her another shot to come in because since we're just dealing with April, because we were much further behind. Let me adjourn it out to the 17th. At 1 p.m. Let's see, and if she doesn't show up or doesn't pay, then I'll deal with it then. Gulfside Lake 1 and 2 versus Dewan Wintermate.
Carissa, what was the last name? Sorry, what was the last name?
Wintermate. That you may not think. I said this for a writ hearing. Oh, I do. It looks like they paid. That's why you may not have anything. And your office sent in a satisfaction.
Yeah.
So, case is satisfied. Well. Gulfside Lake 1 and 2 versus Deion Brown.
Okay.
Sure.
Hello, Your Honor. Deon Brown.
Yes, sir. How are you?
Doing well.
All right. Let's see. Where is he now?
$1,006. I have a note from my client indicating there was that Mr. Watson had indicated no amount in escrow.
Yes, so I have 620 in escrow.
Plaintiff would request that would be released.
Yeah, and how much is your monthly rent?
$675.
Okay. So he paid this on that, okay.
And then I made another payment on the 9th.
So you paid another payment on the 9th to the landlord?
I did it online. It was for something. I'm not exactly the exact amount, but I emailed,
Hold on a second. You paid some 400 on the 9th yesterday?
yeah, I paid after the 620, whatever the remaining balance was, that's what was paid on the 9th.
Got it. I see what you're saying. So do you see that?
Yes, I see $445 paid, so it would leave the balance at 600.
665? Okay. So, and I have 620. So you're about 645, you said, so you're about $25 short.
So technically the late fee is being waived because I paid it before the 10th. I already talked to Melissa. She emailed me. I have the copy of the email. She said she would email the lawyer to let her know.
Okay. Here's what I'm gonna do. Okay. You got that in. So what I'm gonna do is release the 620 to the plaintiff. I'll adjourn this out 1 week. Okay. And let them, because I'm talking about $25. So let that get settled. If it doesn't go that way, just pay the 25 if you got it. Okay.
She told me that the funds had to be released from escrow first before she could remove the late fee.
All right. I'm releasing it today. I don't know when it'll get there. I'll adjourn it out to the 17th, 2026 at 1 p.m. Okay. So hopefully that check can get there. She waives that, then you're all set. Okay.
All right.
If you are, then yeah, I don't need to see you.
Okay.
Okay. But you might want to check before you don't show up.
If it's
Just check and make sure they receive the check.
okay, thank you.
Got it?
Got it.
All right, fella. Have a good weekend.
All right, have a good weekend.
Strong Future Homes versus Ashley Womack.
Area for plaintiff, not checked.
Ashley Womack. Oh, there she is.
Oh, Your Honor,
Hello.
Ashley Bowman.
All right. She just had, well, what do you have as her balance?
I have $2,272.28.
Okay, so she's under the 3. You had her intake appointment with Hawk on the 7th.
Yes, they told me that all I had to do was bring in or send in the paperwork. The only reason I haven't done that yet is because I received the paper yesterday. Do I owe like a security deposit?
Pardon?
I received like the paper from the courts and it says I have a $300 security deposit too. So that's why I haven't turned that in.
300 free deposit?
Yeah. Which is really weird because I've lived there for like 6 years. So I don't know why I have another security deposit.
Hold on a second.
It was like 300.
Pardon?
Ledgers.
Yeah, and I don't see anything on the complaint.
Is there a way to get a paper from here that shows how much so I could send it into Alicia? Because that's the only issue is that the paper I have says I owe $353 security deposit.
I don't know where that paper's coming from, ma'am. Only, and the reason I say that is I'm looking at a copy of the complaint
Hmm.
and it doesn't say anything about a security deposit.
That's really weird. Because the first paper I got, it didn't have it had like 1 cent is what I owed on security deposit. And then the paper I got just yesterday
Is
said
that coming from the landlord or is it coming from
I think the landlord.
Okay, so I don't know anything about this.
Okay,
Okay, so what they want you to turn in is the complaint that you received.
okay.
I think that's the paperwork that Hawk is looking for.
Yeah, they said from the courts of what I owed, so,
Yes, so they're gonna want a copy of the complaint. You would have gotten one by mail. You would have gotten two by mail, and then one would have been delivered to you somehow.
okay. I got them all at once, actually.
Yeah, okay.
So that's,
What I'm gonna suggest you do is get that paperwork, get clear with Hawk what they want. But I think they want your complaint.
okay,
And they're gonna want a ledger or some type that either they'll get from the landlord or from you. So
okay,
you might, what I'm gonna suggest you do is go down to your landlord, get a copy of your current ledger and your paperwork that from the court and get that to them.
okay. You should say
Okay?
that show issued a check, so that's all.
Right. I'm sure that's what they're looking for. They're just looking for that current balance. So let me adjourn this out to the 17th, 2026 at 1 p.m.
Thank you.
and let's see where we are, but make sure to get that paperwork down to them, okay?
Thank you.
All right, Ms. Wolf. Thank you.
Good night.
Then I have Evergreen versus Figueroa. That's dismissed on plaintiff's. And do we? Watson, did more time on that?
Oh, I'm sorry. Forgot to watch. I'm just waiting. I just sent the email, so.
Got it. Okay.
Your Honor,
He looks comfortable saying word. Yeah, go ahead. Wait.
I'm sorry, I didn't mean to interrupt. Is there anything I can prevent to expedite this case right here?
Well, no, I'm waiting. What you said, come on back up. Court calls a Watson. Go ahead, state your name again.
Dwayne Watson.
Okay, go ahead. What do we know?
It's like a zero for plaintiff. I just received an email from my client saying that there is an update from Hawk today. His application is now. So.
Okay, all right. Kind of what I have, well.
Yeah.
I get it. Don't worry about it. We got it solved. All right, so his application's approved. Which, if they cover everything, what do you have as his current balance?
I have $3,510.09.
Okay, so what he's gonna need to get in is 510.
I took care, I didn't mean to interrupt. Go ahead,
Oh,
sir.
no, go ahead.
I took care of that today. I can show proof.
You just doing all kinds of stuff. So you paid the 510.
Yes, sir.
Got it. Which is probably why they approved it, because
Yes, sir.
they paid that. All right. So
Absolutely.
let me do this, Mr. Watson.
I have that now in new ledger as well, so.
You have the 510. So he is at 3,000,
We got
a little under 3,000. They've approved him probably for the 3,000. Got it. Okay. So here's what I'm going to do. I'm going to adjourn it out 1 week. Let that check get through.
Yes, sir.
If they paid it, I don't need to see you.
Okay.
Okay. If they haven't, stop in, just try to make sure you're all clear.
Yes, sir.
Okay.
Yes, sir.
All right, Mr. Watson. You have a great weekend.
Hey, you as well. I appreciate you, sir.
All right.
Right on.
Thank you.
All right. That's it for that block. All right. We're back on time again. Sure that will get all messed up because Mr. Hampton. All right.
I bit my tongue.
All right.
You said that hour block was done. I thought maybe you were on the 9s now. I wasn't sure.
A district court, County of Washington State, Michigan is now back in session. The Honorable Justice
Maybe she. You're on Vista versus Sabrina Jackson.
Good afternoon, Your Honor. Attorney Samantha Sprague, 81931, appearing on behalf of the plaintiff.
I cannot hear her.
That was my fault.
That was your fault? Figures. All
No.
right. Counsel, can you state your appearance?
Good afternoon, Your Honor. Attorney Samantha Sprague, P81931, appearing on behalf of the plaintiff.
Your name?
Sabrina Jackson.
Good afternoon.
Good afternoon.
All right, where are we on her case?
Yes, Your Honor, there is an attorney that has filed a limited scope of engagement in this matter. We have been in discussions. There is a belief that Hawk has stated to the legal aid individual that there is a payment that's been made to the property. My client has not received that. And so we're respectfully requesting a 2-week adjournment in order for us to review that alleged payment and see if we can locate
Hold
it.
on. Just so that I'm clear, you believe there was a payment made?
So I filed with an exhibit before court today of the correspondence between the Hawk representative and myself. She said there was an EFT payment made on, I have an extra one here, if you had it that in time. But it was saying how there was EFT payment made on the 1st for $3,000. However, there is a check block on my account. So I guess I don't know if the payment wasn't able to be made through directly. So right now we're just trying to find out what happened to it.
Okay, so this is why, say it again, why we need Amy. Because I have a spreadsheet that they provided to me. The spreadsheet for your case, I'll make sure I'm looking, has nothing. It doesn't even say that there was a check sent and that it. Mr. Fantera, make a note of that for that next. This is precisely what I was talking about. This is just it doesn't make any sense because well, counsel, you think that
I did receive a copy of the email, Your Honor, and I do believe that Hawk there's a discrepancy somewhere. My client has checked their records. They do not show receipt of it whatsoever. Additionally, no promissory letter was provided to my client, which is why they had initiated the writ. We're willing to go to 2 weeks.
Yeah, I'll adjourn it out 2 weeks, but just so that everybody's clear, what you're telling me would fit with what's on this sheet and not what Ms. Jackson is telling me. Because she's telling me the 3,000 went, and this sheet is telling me there's nothing, which is exactly what you got. So, okay, never mind. I could be on my soapbox all day, and I'm just not going to do that. Because this is a wrong way to treat people. And these people need to understand that this is a court, and I get they're trying to help folks, but they really need to help folks. And sometimes we need a real live person to help me with that. Otherwise, I'll just start evicting people and then they got to play catch up. Okay, I'm
not me. He's
okay. Not you.
I'm kidding. No, it's just been really frustrating. Like even for this court case, I never got anything in the mail. I never got any notifications. I've called, I reached out. It hasn't been any correspondence. I've tried to do my due diligence of what I had to do on my end, but it's scary. I have 2 small children now. Seeing notes like that.
That's exactly what I'm saying. Why I was kind of.
Thank you so much.
That's why just so that you know where part of my, I'll call it frustration comes from is there's a monthly meet first Wednesday and we find out the courts, the judges find out by email that instead of having a real person here that can tell us something and investigate it, that we get this printout of what's going on in everybody's case. And my feeling on that is that's just wrong because if you didn't show up and tell me or couldn't somehow articulate it, there'd be an eviction. They don't get that.
It wasn't easy.
Huh?
It wasn't easy. It was not an easy process, but yeah.
No, I got you. And it just, no, you can send me a piece of paper, but I'm dealing with human beings and they need to realize that. So I'll just say this. 24th is my next 2 weeks out.
That's correct.
April 24th, 2026, 3 p.m. Miss Jackson, I'll just tell you this. Between now and then, certainly nothing's going to happen to you.
Thank you.
We're going to figure it all out. I'm not going to let anything happen to you.
I appreciate it.
And that's before my next meeting, which will be the 6th. So mark that date, Mr. Fantera, because they're going to hear from me. This should not happen. Ever. Thank you, counsel. Jackson, you have.
I appreciate it. But I think
Huron Vista versus Lajah Jones.
Attorney Samantha Sprague-Pete, 1931, appearing on behalf of the plaintiff.
She is not checked in. We don't have anything on that. All right. Would you like to take a default?
Yes, Your Honor.
All right. Raise your right hand. Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth? So help you God.
I do, Your Honor, I do have my client here as well. If I could just take a brief moment to confirm that no payment has been made first thing this morning. I know sometimes it's occur. Ms. McMickens, did Ms. Jones provide any final payment today in the Dropbox or to the office?
No, she has not.
Okay. In that case, Your Honor, we would respectfully request a default judgment.
All right. Go ahead.
Yes, we do show that currently there is past due rent in the amount of $990.10, as well as court costs in the amount of $219.72, for a total due and owing of $1,209.82. I do show that this was a request for both possession and money judgment.
Yes, and they were here at the last hearing. Judgment to the plaintiff, that is by default for possession and for money. Redemption amount and money judgment in the amount requested with the writ issued in 10 days.
Thank you.
Thank you. Huron Vista versus Rakoya Williams.
Attorney Samantha Sprague-Pete, 1931, appearing on behalf of the plaintiff.
Rakoya Williams. No response. Oh, she's on the sheet.
Yeah, I'm calling Ashley.
Pardon? Well, okay. What do you have for owing?
Currently, I show that there is a balance of $2,835.28 in past due rent, as well as court costs of $239.72, for a total due and owing of $3,075.
All right. So here's the note I have from the non-human. Says appointment was on 4/8. Tenant was advised that she needs to pay balance down to $3,000 in order for agency to approve application.
Okay.
Okay, that really told me nothing because that's the rules of the. You know what's sad? Because I don't have anybody in the room that's responsible that I can yell at. Ouch. I might just pick Hamden to do it. You'll just have to take the hit. So I don't know what you want me to do. I mean, she's 75 over, but I'm sure that's just
It's
whatever she did. Yeah, she did what. I don't know if they told her to do this and that they would pay it, or
And
I have no.
we would respectfully request a default judgment. We would note that we will set it aside if we receive a commitment letter and or payment. But that indicates that she can't even apply until that balance is down to 3,000. And she has failed to appear today.
Well, right, well, just so that we're clear, it's not the application, because it says she just needs to pay down the balance in order for agency to approve application. So
Okay.
she had her appointment on the 8th, and so I don't know what they're really telling her, and I don't even know what they told her. I mean, my big fear is they told her, get it done to 3,000 and we'll pay it. All right, but plaintiff should not be just become stupid. That's a legal word. Here's what I'm going to do. I'm going to grant a judgment to the plaintiff. That's by default for possession for the $3,075. With a writ in 10 days. I would just indicate no writ without a hearing. That's the best I can do, but it gives you the judgment, and if they're going to pay, they're going to pay. They need to be a real life person. All right.
Thank you.
Is that it for you? All right.
Happy Friday.
All right. Take care. Oh no, what's wrong?
I left my phone. Sorry.
Oh no, when you leave something and you go out, that's ours now.
It's laughing.
No. Take care. Orchard Grove versus Nathan Alpert. And
Brent
Cochran and Stacy Alpert.
Your Honor, at this time, we move them.
Oh. Case is dismissed. That's without bringing.
Thank you, Judge.
Red Line Apartments. Was that it for you, sir? Oh, okay. Red Line Apartments versus Aiden Lang.
Good afternoon, Your Honor. David Fancher on behalf of the plaintiffs.
Lang? No. All right. Your name? All right. How much is that?
There's rent owing in the amount of $1,390, court costs of $173 for a total of $1,563. Mr. Lang said he could pay that within a week. I told him he had 10 days. He signed the judgment. I signed the judgment, and I advised him of his rights under the court rule.
Sir, is all of that correct? All right. So you can get this paid on the 17th. Okay, and you'll have to the 20th to do it. So, all right, real good. All right, you have any questions whatsoever regarding this, Jeff? All right. Judgment to the plaintiff by consent. I've signed that. You're all set.
Yeah, how we doing? Thank you.
Red Line Apartments versus William Irving.
Good afternoon, Your Honor. David Fancher on behalf of the plaintiff.
Your name?
Good afternoon, William Irving.
Where are we with him?
There's rent owing in this case of $1,700, court costs of $173 for a total of $1,873. Mr. Irving said he can pay basically half this week and then half the following week. So I just gave him till that Saturday, the 25th, to pay the whole thing. And I advised him of his rights under the court rule.
Sir, that's correct that you can do that? All right. Do you have any questions regarding anything on this?
Not at the time, Your Honor.
All right, very good. Then I'll enter the judge. Thank you.
Thank you.
May I approach?
Yes, you may. Is Melissa Daly.
Judge Dominic Camden appearing on behalf of the defendant.
Yes.
Pardon?
So I believe my client may have walked into the courtroom a couple of weeks ago, Judge, and this hearing got set at her volition. I did not find out about it until last Friday, maybe Monday. And so I don't believe she's filed anything based on my conversation with court staff. I don't believe she's filed anything, and I'm not entirely sure Mr. Levine's office has noticed of the hearing.
So what had happened is she walked into the courtroom, explained the circumstance. I think she gave me or showed me some documentation on my staff. Because it involved medical, I did not hold it.
Okay.
Okay, so that's what happened. And then she explained that they couldn't move on the.
That's consistent with my conversation with my client, but I've not seen anything, and neither has my client, to where Mr. Levine's office had filed anything to request a writ.
They have not. So here's what I'll do.
I'm gonna, he'll do it and then I.
Hold on, just hold on. Let the judge talk, please.
Here's what I'm gonna do. We didn't send them notice of the motion, so I'm not sure. Or that there was a hearing today.
I apologize, Your Honor. You did or did not?
Did.
Okay, thank you.
So that was mailed out to them. That was Levine's office with Mr.
I was informed that he was no longer working for Mr. Levine's.
That's right, he is. All right. Okay. All right, here's what I'll do in this case. You're attempting to get yourself out.
Oh, yeah.
Okay, so I'm gonna just indicate that the motion's heard, and just for the purposes of the file, that I will set a hearing should they request a writ.
That's fine, Judge.
All right,
Perfect.
and then that way, I think we can get everybody here then.
Perfect.
Okay,
Thank you.
all right. You do the same. That's the end of that block? Okay. And ma'am, next time, I just so you know, I normally don't do that. You provided some compelling things to me, but next time, probably your best bet is to try to make sure to get to your attorney.
She did, Judge. In her defense, she did.
In this courtroom session, the judge moves quickly through multiple cases, showing both patience and frustration as the docket unfolds. From the very start, the tone is serious, with the judge warning about missed appearances and making it clear the court expects accountability from everyone involved. As the hearing continues, the judge carefully walks the defendant through a no-contest plea for retail fraud, explaining every right being waived and ensuring the decision is made voluntarily. The court emphasizes that even without admitting guilt, the outcome will be treated the same as a guilty plea for sentencing purposes. Throughout the session, frustration builds as cases involve missing defendants, payment confusion, and system delays. At one point, the judge openly admits his patience is being tested, highlighting the real pressure courts face when people fail to appear or follow through. Despite this, the judge still gives chances, delaying warrants, granting time extensions, and trying to resolve issues fairly, while reminding everyone that responsibility and follow-through are critical in court. Question: do you think judges should be stricter, or is giving second chances the right approach? If you enjoy real courtroom moments like this, like the video and subscribe for more courtroom stories.